It's been some time now since the case was decided, and the intention of this talk is to provide a recap of what Lawrence and Fen Tigers said, what it was about, and to go through some of the recent case law developments that have followed since 2014. So Lawrence itself was a case concerning the Mildenhall Stadium, and there's a picture from their website on the screen now. It's a stock car oval racing track, motorsports venue, which clearly, by its very nature, creates a good deal of noise in the area. And it's a nuisance case because in 1984, the Speedway and the stock car track opened up. And in 2006, the claimants purchased a house some 860 metres away from the track. Of course, they bought it knowing the track is there, and they came to the nuisance and complained about the volume and the noise of the racing. The race meets were 16 to 35 times a year for speedway racing and 16 to 27 times a year for stock car racing. So when you apportion that over the weekends, it's virtually every weekend something is going on. So they sought an injunction, and the Supreme Court upheld the first instance judge's decision to grant an injunction, but granted liberty to apply for damages in lieu, and in doing so set out the principles that should be applied when the first instance court was going to be considering the damages in lieu issue. Before we get on to that, there's a couple of important takeaways from this case due to its interesting facts. There was an issue over whether noise can be a nuisance. Yes, it can, depending on the locality. And there was an issue over the impact of planning permission because, of course, the stadium had planning permission. The decision on that was that planning permission doesn't authorise a nuisance, but it is a factor to consider when looking at matters in the round and deciding what to do in terms of remedy. There's some comments made about the case very recently in 2025, in this summer by Mr. Justice Fancourt, and he's clear in his judgment in the Cooper and Ludgate House case that Fen Tigers set out a new approach in which the court has a broad discretion over whether to grant an injunction or award damages, taking into account all relevant factors with the legal burden of persuasion lying on a defendant. So what was actually held in Fen Tigers? Well, as Mr. Justice Fancourt said, the starting point is that there's going to be an entitlement to an injunction, but the burden is on the defendant to show otherwise in a case where a nuisance is established. What Coventry and Lawrence and Fen Tigers did, which was the innovation, was refer to the case of Shelfer, which for years had set out the approach to be followed, and say that those criteria in Shelfer, which have been applied for decades, were relevant but not determinative, and made clear that the modern approach favours flexibility. You may wonder what the Shelfer criteria are. Well, I've put them on the screen there, and it's these four matters which date back to 1895, which even at that stage was a distillation of previous case law, and set out essentially a four-stage test to be applied. And since 1895, these four criteria had been applied very rigidly, very strictly, such that if a defendant was asking for damages in lieu and one of these boxes weren't ticked, very unlikely to get damages in lieu and the injunction would be granted. So looking at some of these in detail, if the injury to the legal rights is small, you're potentially in the running for damages in lieu, but previously, if the injury was large, by contrast, very unlikely to get damages in lieu and an injunction would be very likely. Number two, estimating the damage in money. Clearly, some losses have a diminution in value, which can be ascertained with expert evidence, but sometimes, especially with trespass cases, the actual putting of a figure on the loss is quite difficult, and that difficulty can often be used in the past as a cop-out and an argument to say, well, this is why we need an injunction, because we can't put a figure on it. Number three, small monetary payment. People would quite often in the past argue that if a large payment was required, it wouldn't be suitable for damages in lieu. Of course, what is small, what is large? There's a sliding scale there. And number 4, which is probably the bit which is emphasised the most in the modern cases, is the case one in which it will be oppressive to the defendant to grant an injunction. So, as I say, before Coventry and Lawrence, the approach was to go through those as a tick box list, and if one of them wasn't ticked, you're very unlikely to get your injunction, get your damages in lieu. Modern approach is to apply it flexibly, so those criteria remain relevant, but it was emphasised in the Supreme Court's judgment that a failure to tick all of those boxes doesn't rule out an award of damages in lieu. You can still get damages in lieu, even if 2 or 3 of those boxes aren't ticked. It depends on the individual case. And it made clear as well that there's no exceptionality about damages in lieu. It just depends on what's suited for every individual case. It's best viewed Shelfer criteria as factors to consider rather than as a checklist. There's other factors that are relevant beyond Shelfer, which are quite often neglected in the older cases. And what the Fen Tigers case made clear is that the defendant's conduct and the claimant's conduct are both very relevant. And indeed, as we'll see in the decided cases that we deal with in a moment, is quite often the pivotal factor in these cases. So if you've got a deliberate or a reckless violation of right that the defendant has perpetrated, for example, if they've known that they've been building across a boundary line by a foot, it's been raised with them from the beginning and they've carried on anyway, thinking no court's going to make me tear this down because it's only a foot. If you can prove that intention and that recklessness and that deliberate breach, that makes it more likely you'll get the injunction rather than damages in lieu. Equally, if there's unconscionable behaviour, so if there's smoke and mirrors, so if you get a planning application based on one set of plans, but then you do something to sneak in another set of plans and to try and frustrate the other side's ability to object and put their position forward, that can be relevant. One of the phrases that's used in the case is unneighbourly behaviour. That obviously is quite a broad term. Not every instance of someone being a bad neighbour would mean they'd be slapped with an injunction, but it's a relevant term, and it's quite a useful term because quite often in these cases you'll get one side being deliberately awkward and one side being quite reasonable, and quite often that is relevant as well. Claimant's conduct can be useful as well, so if you delay in seeking your injunction, that can be a factor that points in favour of damages in lieu. Delay is quite often seen as acquiescence. If there's extortion or ransoming going on, so if there's a very minor issue there, a very minor infringement of rights that doesn't really have any impact on anybody, so for example, a foot of land at the bottom of a 20-acre field that's part of a drainage ditch that someone's decided to build on would be treated differently to a foot at the edge of a very narrow inner city access way. And the court will look at, has the claimant actually suffered a detriment to get rid of these situations where a technical infringement of rights is being used as a barrier for development or to achieve an ulterior motive. So in those sorts of situations, damages in lieu can be quite useful tools for the court because it means that justice is done to the situation, even if the amount of money that would have to be paid for damages in lieu is quite large. One factor which is also relevant and keeps coming up in the authorities is that of public benefit and detriment. This was very relevant in Coventry and Lawrence because the argument was that the speedway track was an employer in the local area. It provided locals with entertainment. It was of national importance, so people would come for miles to see the races. And should they be precluded from doing something they've done on that land for 40, 50 years because someone has come to the nuisance and doesn't like the noise? Public benefit can be relevant. It's not necessarily determinative, but it depends on the case. And indeed, there's one case which predates Coventry and Lawrence where a junction was moved in such a way that it violated an easement, but an injunction was refused on the basis that the new access was safer for everybody to use and represented road safety improvements, even though it was a technical infringement of rights. So there's an extract there from the judgment in Fen Tigers, which makes clear that there shouldn't be an inclination either way, subject to the legal burden of it being for the defendant to show why they shouldn't have an injunction made, but the outcome should depend on all the evidence and arguments. So this led to the following concessions made in the judgment, which is an acceptance that there is, as a result of Fen Tigers, the introduction of uncertainty into the law. Of course, as you increase flexibility, you decrease certainty. And the Supreme Court essentially said that it'll be for case-by-case basis to be adopted when approaching how this new approach is to be worked out. Difficulty is that in the cases that follow, there was a tension between how far the Supreme Court was intending to go with it. There were differences of opinions amongst the Supreme Court justices as to the extent to which shelfer should be sidelined or to which it should play a central role. There's an element of crystal ball gazing as to what the result was going to be in any given case in the early days. Things are a little more certain now in light of the recent cases, but even in 2024, Lord Reckitt said that there's little in the way of guidance to be gleaned from the Supreme Court's judgment, and it was essentially opening the door to the good old-fashioned common law creation of legal principles and establishment of a new normality. So the first one of our cases to look at following the Fen Tigers case is from 2014, the same year as Fen Tigers. This was decided very, very soon after the Supreme Court's decision. It was about a right-of-way, a track leading down to a tennis club, quite close to my heart because I do play a bit of tennis in the on-season. There was a dispute over the extent of the easement, and there was a fence put in 6 inches from where the tennis club said the edge of the easement was. You could still get down it, but there was an issue as to whether you could get large mowing machinery down to go and cut the lawns, and whether as machinery grew in size over the years to come, that 6 inches would become important. And an injunction was granted on the basis that the full right-of-way was needed for the grass maintenance activities. This judgment's useful because it sort of foreshadowed an issue that came up in a later Court of Appeal case about whether the approach to take in Lawrence regarding the damages in lieu issue was the same in trespass and nuisance cases. And there was it's almost a counterfactual analysis on whether this case would actually be a trespass case due to the way they'd pleaded it. It was later decided that there is no difference between those two, but that didn't come for another sort of 10 years or so. And the decision ultimately on the approach to take and on whether a strict approach to shelfer should be adopted following the Supreme Court or whether a very flexible approach should be adopted was sidestepped because the Court of Appeal in that case said, well, regardless of which approach is used, there should still be an injunction here because of the facts of this case. So there was almost a failure to engage with the argument there because it was such a clear case in the Court of Appeal's view for an injunction. The next case was 2016, right to light case, where there was building work carried on by the defendants. They wanted to build a new storeroom outside a building and a metal staircase up the side of a building to allow access to the first floor and beyond. And the issue was that proposed development was going to be obstructing lights that went into the claimant's first floor window. And perhaps pivotal factor in this case was that the defendant gave personal undertakings in the course of the litigation that scaffolding would be removed, that they wouldn't interfere with light going into the ground floor window, and that a pillar that was being used to support the external staircase would be removed, such as to remedy the issue. But those undertakings were breached. They carried on with the work. They didn't do what they promised to do, save that the store wasn't built. The staircase was, but the store wasn't. And this was a case where the defendant clearly knew about the dispute, clearly knew about the right to light, and decided to flout that right anyway and crack on because the interference was only relatively minor on the claimant. Minor nature of the infringement in this case is perhaps a good illustration of how the new flexible approach can be adapted to appropriate cases. Because on the shelfer approach, a strict shelfer approach, the injury to the legal rights would be relatively small because of the minor interference with the light going into the building. So it would be a prime case for damages in lieu. But in this case, the decisive factor was conduct and the fact that the defendant had tried to abuse the process by trying to rely upon that rule and that argument to avoid being told to take down what he'd built. There's a cautionary note as well, because Lord Justice Lewison described Shelfer as a gateway to damages in lieu. I'm not convinced this is a particularly good analogy. The reason being because the Supreme Court was very clear that you can still get damages in lieu if all of the boxes in Shelfer aren't ticked. So if the gateway is closed, to use the analogy, you can still get damages in lieu. So it's perhaps an unfortunate way that it's been described there by Lord Justice Lewison in light of the cases that have followed and, of course, a strict reading of the Fen Tigers case. What's also interesting from this judgment is that the trial judge wasn't criticised for considering Shelfer and then embarking on a consideration of all the circumstances of the case broadly. And what is clear from a few of the judgments is that you get differing approaches as to how the judgments are structured. So some judges will begin by going through each of the stages of Shelfer and then doing a holistic overview, all the circumstances of the case, a bit like you would do with Denton, where you go through your stages and deal with everything in one go at the end. And equally, other judgments have not followed the Shelter framework at all, haven't gone through it number by number, and have just done an overall holistic approach. Neither approach has been criticised, so there is latitude for the judges over how they decide these cases. The next case is Rogers from 2017. This was about a restrictive covenant preventing building on land where an injunction was granted. The trial judge was appealed for several reasons, but the key one here is that the appeal was brought on the basis that the judge had focused exclusively on Shelfer, and the appeal was dismissed because the High Court decided that actually the trial judge hadn't focused exclusively on Shelfer. I think the trial judge in this case perhaps held a little close to the wind, in that the extracts from the judgment that are quoted in the appeal do appear to be a traditional Shelfer analysis, where the actual thought process seems to be done in terms of Shelfer and the 4 stages there. But the way that the High Court justified the decision was to say, well, actually, because the circuit judge has made findings on other factors, he clearly hasn't put those out of his mind when he's been deciding the case, and it would be wrong to suggest that after making those findings, all he's focused on is the 4 parts of Shelfer. So that's perhaps an example of maybe a generous appeal court, but it's a cautionary tale because if you focus exclusively on Shelfer, it was accepted in principle that there's a problem there. But those cases where it can be said the judges truly focus exclusively on Shelfer when findings are made about other matters are probably going to be in the majority. This next case from 2019, very catchily named, is about loan notes and securitisation. Nuts and bolts of it is the defendant wanted to interfere with the securitisation structure despite having no standing to do so. And they were proposing to go off and tell note holders and the market they were going to do certain things when actually they had no right to do those things. So it was almost an economic tort kind of situation. And in that case, the injunction was granted. 3 out of 4 of the Shelfer criteria weren't satisfied because oppression wasn't found. It wasn't going to be a small monetary payment. It wasn't going to be a small injury. But again, defendant conduct was the decisive factor. Yet the decision was made to grant the injunction after considering matters in the round. It was made clear in that judgment that Shelfer wasn't a barrier to damages in lieu, it's only informative. So you can go through the Shelfer criteria and make a decision even if it's contrary to what the traditional outcome would have been. Now, this is a case that most in the room will probably have been aware of from the press. The great Lidl and Tesco dispute, which is probably up there with Colin the Caterpillar in terms of notoriety. The decision at first instance in that case was that there was a trademark infringement because of the similarity of Tesco's club card prices logo compared to the Lidl logo. That decision on trademark infringement was overturned by the Court of Appeal. An injunction was granted at first instance, but the propriety of granting that injunction wasn't reviewed at the Court of Appeal level because the liability decision had been overturned. But the High Court's judgment does set out the basis upon which the injunction was granted in that case. Shelfer was still used as the framework for the decision. And it was said that it's unusual for an injunction to be refused where shelfer are not fulfilled, though not impossible. And the words heavy burden were used if a defendant is to show oppression. So this is perhaps a move back towards a strict approach. It isn't a complete move all of the way, but it is perhaps a useful comment on where the burden lies and how that burden is to be applied. But what's important is the third bullet point there, in that the stage 4 shelfer oppression, is it going to be oppressive to grant an injunction, is essentially a proportionality test. And proportionality is what was front and centre in Mr. Justice Fancourt's recent case of Cooper and Ludgate House, a very large office building, 19 stories, called Arbour. Planning permission was obtained to build this structure as part of a wider development. And of course, by the nature of it and the size of it interfered with the light that was going to flats occupied by the claimants. There were a lot of people who were affected by this. A lot of them were bought off and accepted cash settlements, but 2 of them went all the way to the High Court to say that they wanted an injunction to have the building either torn down completely or modified to not interfere with their rights of light. Mr. Justice Fancourt didn't grant an injunction in that case, but awarded damages in lieu instead. Why was it refused in that case? Well, futility was one of the points, and this is quite a fact-specific point in this case, because there was a Section 203 resolution made pursuant to the Housing and Planning Act 2016, which essentially allows a resolution to be made which enables development even if it violates property rights and easements and rights to light, and essentially says that you can carry on with your development even if it violates those rights, and any remedy is limited to damages. So the point was made that even if the building was torn down pursuant to an injunction, they could get planning permission for a similar building again and rebuild it on the same footprint, have the same impact, and only have to pay damages. Proportionality was front and centre here because the cost of demolishing this building was going to be 15 to 20 million pounds. The rebuild cost 225 million pounds, whereas the diminution in value to the claimant's flats was 20,000 in one case and 60,000 in the other. So it's perhaps a David and Goliath situation here. Proportionality wasn't the only factor that was considered. The public benefit in this building and its centrality to the new development was also very important, but also was the fact there was no reprehensible conduct from the defendant because they'd consulted properly, they'd engaged with the claimants, and indeed they'd made offers to settle the claim prior to litigation. So it was a situation where the public benefit and proportionality were the key factors here. But what's important in this case is that shelfer wasn't used as the framework for the decision. It wasn't a case of going through the stages robotically. It was a very holistic approach which looked at the matters that were specific to that case in detail. It's quite an interesting read as an up-to-date authority on that matter. Interestingly as well, there's no finding that the interference with the claimant's rights was small, because artificial light in their houses, in their flats, were needed all day in order to bring the light up to the proper level. Damage was found to be hard to estimate in money, because how do you put a price on that other than diminution in value? And the money award that was made in that case was quite large. Negotiation damages were awarded, 350,000 to Mr. Cooper, 500,000 to the Powells. So if you were to look at this in shelfer terms, well, is this a small damages award? Well, clearly not. It's a massive damages award. So this is a very good example of a case where the decision would have been very different on the old approach, where if shelfer had been applied strictly, very unlikely to get damages in lieu. There's an interesting comment as well that the measure of damages is relevant to the decision on the injunction. And Mr. Justice Fancourt says that in the event that he's wrong on the basis of damages, whether it should be negotiation or diminution in value, then if it was limited to diminution in value, 20k, 60k, then that wouldn't be adequate compensation, and that would point towards the grant of an injunction. So it's a judgment where all parts dovetail together, very cleverly put together, and very useful as an example of how this modern approach is to be applied in practice to quite a unique set of facts. So the takeaways from today, Shelfer criteria informative, not prescriptive. The tick box days are over, but you can still use it as a structure if you want. Damages in lieu aren't to be seen as exceptional or restricted to low value cases, and the Cooper case is a very good example of that. Conduct is highly relevant. The case about the stairway and the breaches of undertakings is very good illustration of that, where a minor infringement can still give right to an injunction when someone's done something inequitable. But it does mean the outcomes are often harder to predict because you can't rule out damages in lieu just because a tick box hasn't been ticked in Shelfer, which was often the case previously. So it requires a holistic approach, a holistic review of all matters, and of course timely advice to the client about what they can expect moving forward.